recently, what's his name? Miracles. He came out to say that nobody questioned him about 55 million, that it was questionable. And people believe that. People believe that. Because Miracle is saying it, everybody believes that that is the truth. And nobody is even interested in asking EOCO, how do you even conclude that is true? And you see, EOCO is not under any obligation to be responding to things like that. Law enforcement, we are not under any obligation. At the end of the day, we will bring you to court. We will charge you. You will have your day. So whether we ask you about 55 or we ask you about 5, it's not even our headache.
My neighbor I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Yeah.
Let's look at issue around bail, because for a lot of people, particularly in the last couple of years, the concern has been that bail is being used as a form of punishment under this administration. As Deputy Minister for Justice,
I also get a bit, you see, the bail issue, bail is based on a number of factors. The nature of the crime, okay, is one of such factors. Even the accused person's behavior, past, present, or likely behavior, they're all part of it. Okay. If you are investigating someone who has stolen 10 CDs, and then you put the bail to 1 CD, the person is likely to break the bail and pay 1 CD, or get someone to pay the 1 CD. So usually the bail is measured based on the nature of the offense. In, I think, this Sagleby, they gave a bail condition that was, as at 2021 or 2022, was running into how many millions, hundreds of millions of because of the nature of the subject matter. So I think people use their personal circumstances. So if you say someone's bail condition is 50 million, and then I look at myself and say, oh, I have never seen 10 million before. So how are you asking someone to use 50 million to put bail? But the truth is, the person maybe is being accused of stealing 500 million. So we always need to match what is at stake and the bail terms. Of course, I am not oblivious of the fact that there are situations where bail is quite excessive, but even then, courts have given bail conditions which accused persons have not been able to satisfy because of the same problem. If you are accused of something, you need to get people to come and bail you. It's people's willingness to bail you that determines what should happen. Someone cannot satisfy bail condition of 1 million. Another person can satisfy 50 million, 500 million. It's all about variances. So again, when you run the facts, you will see that it is not really true, especially when it comes to EOCO. I think there's this narrative that EOCO has been using the bill, but when you
can you blame people when they think that?
No, I'm saying that, you see, you are a media person and you know how narrative can create perception, and the perception can become a belief. EOCO grants bail, and sometimes when we go to court, the court even give higher bail conditions to the person. So when you look at those things, you realize that it is not even truly, it's not correct that EOCO give excessive bail, because EOCO gives a bail and you expect that, okay, we all believe that at least the principle of the court will be fairer than, but the courts give even sometimes higher bail condition than EOCO in respect of the same person.
We have also seen instances where the bail will only be given in last minute.
And let me ask you, there are accused persons, okay, who would, during the interrogation, they prefer EOCO bail condition to going to court. If I told you, you won't believe, but the accused person, when you say, let's go to court, they say, no, we are working on it, They don't even want to go to court for that bail situation. And about the lateness.
The last minute bail that is given.
No, see, again, there is nothing like last minute bail. The Constitution is clear that you cannot hold someone beyond 48 hours, right? So when you come to, when it's 48 hours, the 48 hour is the red line that you don't cross. So So anytime you are getting to 48 hours, you know that you are running out of time.
Then we give bail at a point when the person cannot bail themselves.
No, you see, when they give you bail at that time, the law doesn't say that you shouldn't be taken to court until you satisfy it. You are always available. I mean, the court is 48 hours. 48 hours, you should be before a court of law. So, I don't know how else to explain this, but the point I'm trying to make is that...
What I want you to address is person A is taken in by this investigative agency or law enforcement agency.
Yes.
And for 36 hours they have been there. 47th hour they grant the person bail. By 48th hour you haven't been able to
yes, that is what I'm
meet
saying.
your bail conditions.
That is what I'm saying, that when it's 48 hours, it has nothing to do whether you have been able to meet it or not. You are supposed to be sent to a court.
To court.
That is the position of the law, and no one can dispute that. So it is not, the 48 hours is not dependent on whether you have been. So when they give you bail, and I want the public to be aware of this, okay?
Right.
When they give you bail condition, you are not bound to satisfy the investigator's bail condition. You are entitled to be sent to a court for the court to determine the bail. But I just told you that some accused persons said they don't want to go to court. It's because sometimes they know that when they go to court, the bail condition may even be worse or may be unfavorable. So they will prefer, let's remain here and find a way to sort it out. And you see, a lot of things happen which we law enforcement people cannot put out there. You keep someone, you give someone condition, you want to take the person to court, oh, I'm working on it, hold on. The same person goes out and says, hey, they've kept me for more than 48 hours. When that 48-hour delay is his own request. So a lot of things happen. So my caution is that we should not treat the reports of persons who have gone into detention and are out and are saying something else. Recently, what's his name? Miracles. He came out to say that nobody questioned him about 55 million, that it was questionable. And people believe that. People believe that. Because Miracle is saying it, everybody believes that that is the truth. And nobody is even interested in asking EOCO, how do you even conclude that is true? And you see, EOCO is not under any obligation to be responding to things like that. Law enforcement, we are not under any obligation. At the end of the day, we will bring you to court. We will charge you. You will have your day. So whether we ask you about 55 or we ask you about 5, it's not even our headache. Eventually, whatever we find on you, we'll bring it to court. At that point, we have had situations where people have said nothing. In the end, did they not say that they want plea bargaining? When they said no, we came back, they just kept us there, they didn't ask us any question. But the moment they are charged, they said they want plea bargaining. So I want the public to understand that law enforcement, because of the nature of the work we do and because it's investigation, it's not everything that law enforcement can respond to. But that doesn't also mean that lack of responding to some of these things means that the person who is saying it is right or is correct. That's all I want the public to just be very aware of that.
Is Dennis wrong in that when he tells
of course, he's completely wrong. I mean, you cannot say that it was no question about 55. Completely wrong.
Was he questioned on the 55 minutes?
Yes.
I see. So he's very much aware of why he was kept in there.
Let's not even go further. He's very much aware.
Let's discuss the tribunals now. The law has been passed, but there's still quite a bit of a discourse around it because some people think that bringing this back is not good for the justice system. What do you think?
See, what is the key feature of the tribunal? I think we need to go back to the basics. Sometimes you say you give a dog a bad name, then you hang it. What is the key feature of the tribunal? The key feature of the tribunal is to allow public participation in the trial of people, which is a basic human right. Let me tell you, in other countries, you don't prosecute someone by putting one judge in the chair to decide the person's guilt or innocence. You don't do that because it follows the principle that two heads are better than one.
Right.
So it is fairer to have a number of people trying you for an offense, which will lead to the deprivation of your personal liberty. It is better to have more people trying you than one person trying you. So, but you see, we have been colonized. Okay, it's a result of colonization that we don't even have jury trials for every offense. Even in civil cases in other countries, you see that jury is brought in. If you remember this actors Jack Sparrow.
Right. You're correct.
In other countries, even civil cases are tried with jury, because it is actually unfair and unjust to judge a man by the standard of someone that is not related to. The things that I will see as extreme would depend on my circumstances. And that is why even in jury cases, they say lawyers are not allowed to be jurors, because the mind of a lawyer is different from the mind of the average person. And to say that someone has done something wrong against the public, you should use people of his kind, people in his circumstances, decide whether he is wrong or right. That is the standard principle for criminal jurisprudence, criminal trial everywhere, except in the former colonies. When the British came here, they decided to limit the jury trial to only murder and some offenses, because they made a very bad remark about us. They said we are not even capable of ourselves determining that. So they invented a system where one judge will sit and determine whether you are guilty or not. Now we have a system which is giving us an opportunity for people like ourselves to be part of those who determine whether we are right or wrong, and we are here arguing whether it's good or not. It's like you are being given a better opportunity for your guilt to be decided, and you say no, you don't want to. You want a judge. Look, I went to law school. I may not have any knowledge in whatever is happening among the people in Nima, what they consider as right or wrong. But if I become a judge and you bring somebody to me from Nima, I'm going to use my mindset, which I grew up with, to judge a person on questions of facts. And that will not be fair. If perhaps you bring someone from Nima to sit on the panel, that person from the Nima place is going to have a certain understanding of what has happened. So I think it's even an elite view to think that, and it's even statistically.
And so when the counter argument is that, look, we are bringing back a history that this nation should forget. Does your office?
Let's talk about history. Do you know what constituted even the one-man judge trial that we are comfortable with? Do you know the history of it? If we want to deal with history, even this whole idea of democracy, do you know the history of what became democracy, what became the foreign judicial system that we had? Do you know the history? So if you want to use history, a lot of things that we cherish today will not, even this democracy that we are enjoying, the history of it, was it not born out of coup d'etat? So are you going to say that because of coup d'etat, so we cannot have this democracy, or we should throw this constitution away? So it is quite a very difficult argument to accept if you understand that things become, even gold is taken from the mud. Are you going to say because it came from the mud, so then gold is not good? Diamond is always taken from the mud. So you don't use such analogies to determine whether something is right or wrong. You look at what is offered and you judge the thing by its features. So I don't know why. I understand the psychological effect of, people used to be caned by this thing. So if you are bringing the tribunal, is just English language. In some places, they don't even have court in their work. They call it tribunal. So you calling it tribunal, you could have called it anything else. But as lawyers, what we look at is not how something is called. It is the feature. So for me, as a lawyer, when I take the bill, I look at it, okay, does it satisfy fairness? Does it deal with the issues, the challenges that we have in administration of justice? Those are the things I will look out for. And for a human rights lawyer like me, I have no doubt in my mind that it is always better for more than one person to judge me than one person judging me. And that is even the principle why when you go on appeal, they add more, because the belief is that when you have more people determining the same issue, they are likely to be right than when there's one person. That is the same idea that we used to, we add 2 more, when we go to the Supreme Court, we add 2 more, then we go, that is it. And
the other aspect of the fear is that this administration is setting up these tribunals, or wants to set up these tribunals, just so you can persecute the opposition.
you see, that is even a problem, because there's all the human rights that we have in this country, they are all in the Constitution. Any law which is in conflict with any standard set by the Constitution is unconstitutional and null and void. So if your fear is that every right that an accused person has is not in an act, it's not in the legislation, it is in the Constitution, the right to be arrested, the 48-hour rule, and to be given a right to counsel of your choice. These are all constitutional provisions. Anything that anybody does which is contrary to any of this is unconstitutional, and you will challenge it. So I understand people, the fear of new things. It's not even new anyway, but I mean, for many people, it's a new thing. But the fear of the unknown. But the fear of the unknown has not been a very good company to development.
I want to talk about influence and corruption for cases that go to the tribunal. How do you hope to cure that in the new system that we will set up?
Mathematically, it's easier to influence one person than to influence a number of people. That is why when somebody appeals a case, they add 2 more. Because we believe that if the one person is wrong, 2 more will make it a bit fairer. So if it's about influence, and we know judges too can be influenced. So if it's about influence, then why are we comfortable with one person sitting there, and we don't concern ourselves about influencing that one person, and we are now worried about influencing more people? Logically, it doesn't carry a lot of water to tell me that it's more difficult to influence a judge than to influence multiple people on a panel.
How do we plan to fund and find human resource for this?
Human resource for the tribunal?
Yes, and how do we plan to fund it? Their existence?
From the budget.
Okay. Isn't your budget already limited?
You see, the tribunal is not going to be dealing with, so you have, let's say every year you have 10,000 crimes brought to court. This year there will be 10,000 crimes. What the tribunal is doing is that instead of putting all the 10,000 crimes in the normal system, we are now going to put less on the normal system and put some on the tribunal. So it reduces the delays and the burden on. That is what the tribunal is going to do. So it's not as if the ordinary court system is still going to continue to have all the cases, and we are creating new offenses for the tribunal to handle. So the tribunal is basically dealing with the same caseload that would have been dealt by the regular courts.
So you don't find that you would have a human resource challenge or funding challenge that could prevent you from properly operationalizing the tribunal system?
It is not that we always will have human resource challenge. Okay. Even without a tribunal, we would have. Even without a tribunal, we'll have funding strategy. But what the tribunal is doing is to try to fast track. You see, the problem we have with the normal court is that what we call the delays, the workload, the delays, and most of these delays are due to rules of court. Okay. Rules of court. See what happened. We're discussing the Wontumi case, for instance. Okay, that's just a tip of the iceberg. As a prosecutor, every point in the case, somebody can just raise any objection, and they will go and then come back and we will go. So if you are not careful, a single case. I mean, take for example. We always accuse the OSP that we have not gotten any. OSP has been in existence for some time, but the system is such that it may not necessarily be that they are not working, but it is what it is. Unless we are saying that we don't care about it, we are okay with that kind of system. If we are okay, then that is a question that all of us have to do. We like what we pretend to be complaining about. But if there's a mechanism to solve a problem, I think let's try it.
In terms of this operationalization, okay, we are going to have a judge on this. We need to find a human resource for that. Are we now going to be using judges from the traditional process? We are training more judges. what exactly are we doing? Okay, we want to draft people from the public. How are we drafting the people from the public to ensure that it cures problem of any of the concerns that have been raised already?
The concerns that have been raised have not been about how you are going to get it drafted. So if you want us to discuss the concern, which we have been doing, it will include how you are going to get the judges, because the law tells us it should be this number of years to be able to sit on this regional tribunal, number of years at the bar, to sit on the district, to sit on that. My point is that my understanding of what you mean by human resource is the other people, not the judge.
You don't think it will be a problem to get judges to sit on panels? You won't have challenges at all?
No, I don't think so.
Okay, so while we get judges to sit on those panels, what happens to the traditional court process? Because we are going to need judges there as well.
We need judges there. So is it your point that the more judges we have here, the less we have there?
It would appear so, until you give me an explanation of where you find your human resource. Because if you're going to take from the traditional process to the tribunal, then I'm thinking, okay, those 7,000 cases you might leave there from the 10,000 example. What happens to those cases when their judges, some of their judges may have moved to the tribunal?
I think, let me, you're not getting this point. The cases are piling up because of the process, the procedures.
Okay.
Do you get it? So you may have 100. One of the things that when we're doing ADR, one of the things that we say is that you can even recruit 1,000 judges per week, or create or produce more lawyers, but so long as you don't deal with the process, the reason the delay will not end. So the reason why, if you take a case to arbitration, it's likely to be faster, quickly, resolved than the court, is because of the procedures. So it is not a human resource that is the issue. You can bring the most efficient judge, but if the court procedures are so sluggish that they are not allowing cases to move, you can't move. So it is more about the procedures in the system, in the tribunal, as against the procedures in the regular court. That is the difference.
So it really wouldn't be a human resource issue. It would be that the law.
Not more than it's already a human resource issue, even in the right now.
Even in the traditional.
Yeah, we need judges in the traditional, and even though we have produced many lawyers, not everybody wants to be judge. So the issue is not whether we will need judges or we will not need judges. It will be which procedure gives us a quicker way of resolving disputes than the other. And there's no doubt that the tribunal, if it is allowed to function, will give us a quicker resolution of dispute than the normal court. The issues I understand people are raising is the memory issues that these tribunals, they used to cane people, they used to do this, they used to do that. But I don't think anybody believes that today in Ghana, a formal tribunal will call someone and start issuing lashes. The same punishment that you get from court is the same punishment, the same crimes that you get from the normal court is the same thing. The difference is only the procedures that will be used.
The former vice president has asked for wider consultation on this. How consultative was this before it was passed?
I think there's the former vice president's position is a bit problematic, in the sense that it is based on the assumption that this is a new creature. It is not new, it's already in the constitution. So it is not as if Ghanaians are now going to decide whether to have, it is already decided and it's in the constitution. So if we are asking for, of course, there can never be enough consultation. And I'm also pro consultation, because democracy is based on consultation. So if we are asking for further consultation, I would say that is necessarily a bad idea, but consultation on what? Is it consultation on whether to implement, because it's an implementation of a constitutional provision. It is a consultation in respect of what, right? If something is already a constitutional mandate which is being implemented, why is that what we should have consultation on? But if the consultation is on the procedures, the things that we need to, then of course we always need consultation, but how much consultation can we say is enough? We've had kind of Furiata issue that we are dealing with. We've had said enough issue. So you will be an irresponsible attorney general when there's a bank calls you, gives you information, you did your check, and then you say, because of what people will say, that you are using state power, so you allow the person to go, and when the person goes and doesn't come back, you think the Ghanaians who gave you power, who gave you a mandate to govern this country, will be happy that because of your fear that they will say you are using the power that you have been given legitimately, you have allowed someone to travel out of the country who cannot come back, or who will not come back, and you use Ghanaian taxpayers' money to now be engaging foreign countries and to get extradition. Of what wisdom would you be boasting of as an attorney general or any government official if this is what you are doing?
So the state had reasonable, well, not
suspicions,
but you had reasonable suspicion.
Yes.
That Hanan was traveling not to go and see his ophthalmologist, but to escape justice.
It could be that he will see his ophthalmologist, but the core issue is not whether he will see him or not. The core issue is, we call it flight risk.
Okay.
What is the level of risk? So we do analysis. This person, is it likely to come back? You know, a lot of Ghanaians, or some Ghanaians are familiar with visa. When you are going for visa, they will say this person is not likely to come back. It is not. It may be true that he will go and come back, but they are just saying that when we look at all these factors, you fall within a category of persons who, when they travel, are not likely to come back. That's what the visa people use. So there's a whole analysis that.
So was he already on a no-flight list?
Yes, he was on the stop list. So what the court did when they applied to go to do the medical, we considered the court considered and said he can go. Then after he was given the leave, then he now decided to do these things that I mentioned, which made him, in our view, a more likely person not to return than he was when the court made a decision. And that is a normal thing. If the court grants you bail, okay, it grants you bail right now, go and come to court, and you go and commit another offense, or you go out there and you are going to interfere with evidence, the court will revoke the bail and put you. So it is a normal, it's not anything new, it is the normal thing that the courts, that happens in the courts.
Let's move away from that, because there are other oral cases that you've been looking at.
Yeah, so then after that, there's Aboagye. Aboagye, our fourth witness, is in the box, and we hope that by this week or next week, it would have been discharged. When that happens, then when he's discharged, it means that we have closed our case, and then the accused person will finally be given the opportunity to come and mount his defense, because over the period, at least we can identify about 3 or 4 defenses that he has been trying to put across, which makes the whole case quite interesting, because at the point, we believe they were saying that they actually bought the equipment and that the equipment is there. Then at the point, they seem to be saying that the money was a loan that the accused person gave and that he was taking it back. At a point, he even published a list of politicians that he said he gave the money to help in their campaign. And then at a point, they said it was so, and all these explanations are contradictory. If the money was used to buy the equipment, then it cannot be the money that you used to sponsor the politicians. Then it cannot be loan that you were taking back from the company. Then, so I find it fascinating that this is the kind of explanation that I've been given so far at the first half of the case. Recently, there was an issue also of they made a request for disclosures on the source of money in the government bank accounts. And then we said we do not have any information about the source of the money before it came to the government bank account. And there was this whole issue about, if you don't know about the source, then you cannot know what it is. And I find it quite interesting, fascinating, because any money in any government bank account is for the government. And if you are prosecuting someone from stealing government money, you don't need to go and find out whether the money came from taxes or from foreign loans or from the sale of natural resources, or however the money came into a government bank account. It's of no moment. Once the money enters the government account, it is government account, it is government money. And to take it out, you need to follow certain procedures. It is the lack of that procedure, which is constituting the stealing. The accused person took money from government account, okay, and put it in a private account, and immediately within 6 months spent it on specific things. We have put all that evidence before the court, right? So I, in my mind, have no doubts whatsoever that these things, it's not a very complicated issue. You asking us how the money came to be government money is of no moment to the issue. If you are in secondary school and you overpay your fees, do you say because you overpaid your fees, you go and take you go to the business office and you take money and put it in your pocket and say, because I overpaid my fees? Right. You have to follow procedure to get a refund. So no matter how you think the money entered the account, once it's in the account, it's government money. And unless you follow that procedure to collect the money back, there's no basis for what we are saying. But again, I have observed that when you are prosecuting, and this is my first time being a prosecutor, so when you're prosecuting, especially in these highly sensitive cases, there are people who constitute themselves into departments of misinformation. They try to do everything to make sure that either they put the judge into disrepute, or they put the lawyers into disrepute, or they put the facts into disrepute, so as to blind the public and create a certain narrative. But we are very focused. We have done our investigations, we have our facts which we have put before the court, and we will not allow any department of misinformation or disinformation to confuse us or the court.
Very well. How many of the oral cases are we prosecuting now in total?
I think we have, I think we are between 5 and 10 now.
5 and 10.
Advanced stages.
At varied stages.
Yeah.
Of prosecution.
Advanced stages of.
Okay.
Yeah.
Oh, very well. And how many in total are in your report?
When we analyzed the report, I think we had about 30 cases that we thought
were prosecutable.
Yeah,
so we are looking at like a third of them being prosecuted now.
Yeah, we have other dockets already, but we are going to start with them either during the vacation, the legal vacation. We are going to start new cases. Yeah.
Which brings me to the question on what we should expect from October when the legal year begins.
We will continue. I mean, we will continue what we have done. Okay. We are going to continue prosecuting. As far as the oral is concerned, we are going to do it.
Any big case coming up?
Oh, let me just hold on to that.
Why?
There will be other cases. When we're working, we don't actually focus on which one is big or which one is that. We focus on which one is prosecutable. But I can tell you there will be some interesting cases coming soon.
I see.
Dedi kama amena PENDREAM TV ase. Now so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.